Uh, Good afternoon, or good morning, or good evening, dear colleagues. Thank you for joining us today. My name is Maria Tomak, and I represent the Media Initiative for Human Rights, Ukrainian NGO dealing with the issues related to Ukrainian-Russian conflict, armed conflict in particular. And we are welcoming you within the next webinar within the series of webinars which are organized by the Media Initiative for Human Rights, Ukrainian Helsinki Human Rights Union, supported by the USAID Human Rights in Action program, and which is moderated by my colleague Katarina Buso and myself. And the purpose why we're doing this webinars is actually to combine the international legal context and the Ukrainian one, since we believe that there are a range of issues that are actual for Ukraine in our current circumstances and related to all the range of legal issues that we are facing, but also that are actual for the international community. And obviously, the impunity for the international crimes, this problem, is actual for international community, but for Ukraine as well. And we would like today to focus specifically on one of the instruments which is aimed at combating this impunity, and it's a universal jurisdiction. And we're joined today by distinguished guests, in particular from the overseas, and my colleague Katarina will introduce them. And I would like to specifically say that what encouraged us to invite these particular legal professionals and, as Katarina said, legal stars of the universal jurisdiction issues, is in particular the recent case which was highlighted by Ukrainian media and which draw some attention from Ukrainian public, is the case of one of the Syrian officers of the security service who was convicted by one of the German courts. And of course, the question which was and why this case drew attention from Ukrainian public was whether it's possible with Russia. I mean, whether German courts could potentially bring to responsibility some of Russian officials who might be engaged in some crimes in the territory of Ukraine, whether we're speaking about Crimea or Donbass. And also, of course, Ukrainian law enforcement services has been examining and looking into different possibilities of the fighting the impunity or different criminal instruments that are available at the international level in order to try to use them for persecuting the international crimes, those who might be engaged in the international crimes in Crimea and in Donbass. And universal jurisdiction was on the radar, but it has never been used because it's a very complicated instrument. But also, why is it so? We will figure out today because one of the key, I would say, figures when it comes to the investigation of the international crimes in Ukraine. Joining us today is Gündüz Mamedov. Mr. Gündüz Mamedov is Deputy Prosecutor General of Ukraine, and I should say that he actually inspired the launching of the special department in the Office of General Prosecutor for investigation the crimes against humanity and war crimes in the territory of Ukraine. Before we will proceed with the introduction of our foreign guests, I would like to make a few technical notes. We are live streaming to Facebook in Ukrainian language or in Russian language, and to YouTube with the English interpretation or in English. I would kindly ask the speakers to speak slowly so that we can properly translate your speeches for the audience, which does not speak English or Ukrainian or Russian. And also, if you would like to listen to Ukrainian interpretation, you can find the button called Interpretation and the globe button in the bottom of your screen, and choose the option which is called German. So that's where you can find the Ukrainian or Russian interpretation. So, Katerina, please proceed with the introduction of the guests.
Thank you very much, Maria. Thank you very much to our panelists who are joining us from very different corners of the world. And thank you very much to our audience who are dedicating their morning or late evening to international law and to the issues of justice. Our two distinguished foreign guests today are Ms. Almudena Bernabou and Mr. Wolfgang Kalek. Ms. Almudena is a co-founder and co-head of Gymnica 37 Chambers. She has been widely involved in different international law, including international universal jurisdiction cases around the globe, namely in Guatemala, Chile, and other states, bringing them before the Spanish courts. And most recently, she made news with this Jesuit murder case, which is being now considered by the Spanish court. Mr. Wolfgang Kalek is the General Secretary of the European Center for Constitutional and Human Rights, and he and his team also made great news recently with the famous ruling with respect to the Syrian member of the Secret Service who was convicted for torture as a crime against humanity. Wolfgang has had an impressive career, and he started as a criminal lawyer and then was involved in the proceedings concerning the Argentine military junta and their crimes against the German citizens. And now he also publishes widely, and I will mention the books of his later at the end of the webinar, because at least two of them, very impressive ones, are available online, and it's wonderful that we have access to them. Our speakers will present for 10 to 12 minutes each, and then we will have a Q&A session. So as Maria has mentioned, please type your questions here in the chat questions function, or also if you're joining us via Facebook or YouTube, please type your questions in the comment sections there, and we will read them out loud. And now I give the floor to our first speaker, Ms. Almudena. The floor is yours.
Thank you very much. Can you guys hear me all right? Because the technical is always perfect. It's a pleasure. Thank you so much, Maria and Katerina and the Media Initiative and everybody, always civil society involved in this kind of efforts. And it's an honor to, and Mr. I will destroy the last name, sure. So, but it's an honor to have someone also from the prosecutorial unit and someone that I know about that has been trying to push a little bit for universal jurisdiction and war crimes investigations and the like. And an honor to be here. I'll try to see if I can respect my time. I am known for not doing so. So let's see if I can be disciplined. I was hoping to go a little bit, and not, I think everybody knows what universal jurisdiction is in 2021. And someone that preceded me in the introductions mentioned there's a very difficult provision. And I thought that it would be interesting to talk a little bit. As a Spaniard, I have a life that touches several countries, but I am from Spain. I'm a lawyer in Spain, and I was lucky enough, and that's how Wolfgang and I know each other. We will not tell you for how long we know each other, but that's how we met. I was lucky enough to be almost beginning in my career when a number of professionals in Spain, lawyers and colleagues of Wolfgang and now mine, we're exploring Spanish accidentally, and I think Wolfgang will agree with me, accidentally opening this spectrum of national investigation of international crimes. So I think it's worth perhaps doing a little bit of memory on how this came about and quickly going to an evolution that I witnessed, but most likely where we are now and where I think some of the challenges the countries such as Ukraine and other countries that hope perhaps to open their jurisdictions and their professionals to these opportunities, I think face, or in my opinion, they should very much take into consideration as the world keeps going in this sometimes unfortunate direction where these crimes still are committed and they are generally different. In the Spanish case, it will not be surprising that to many, Spain is a system, just very quickly, that has done very little to evolve from an inquisitorial legal system into a more accusatory one. So it's still a system, perhaps the Ukrainian colleagues may relate to this, where investigative judges and prosecutors carry formally the entire weight of opening investigations. But in this kind of, if you wish, archaic way of understanding our legal system, something was never changed. The private action or the private ability to be part of the criminal proceedings and to start the criminal proceedings. And we have two formulas. One is called private prosecution or particular prosecution. And another one, quite significant and rare these days, is the popular prosecution. This ability that any person, legal or physical, not necessarily related to the events in question, to the criminal events or the crimes, just to be more precise, could actually trigger the interest or could bring to the attention of the prosecutorial units the request, a legitimate request, naturally, not frivolous request to investigate the commissions of the crimes. That precipitated, and I would like, something that I'm going to go over in my 10 minutes, which is the importance, and I don't think I can emphasize it enough, of civil society understanding that the moment has come to really trigger this possibility. And the importance of a civil society, my opinion, is not antagonistic with the legal, judicial, prosecutorial units, but it kind of finds a way, and that would be, in each country will look differently. The German experience is quite different than the Spanish one, for instance, but they've been there. And I think that the ACCHR, the organization that the Wolfgang represents, for instance, was very much there as things were changing in Germany. So civil society brought these cases. Ironically, perhaps for those who may not know these, in Spain, the universal jurisdiction provision, I like to say this because, for instance, in the United States, people are shocked, is only as procedural rule. It's not a substantial rule. So when in 1996, the very first case was triggered by a prosecutor in Spain, Carlos Castresana, specifically in this, kind of brings us all together on the Argentine junta, the military junta crimes committed during the dictatorship, the repression in Argentina. They realize, and perhaps this is useful to Ukraine, the substantial law, the criminal code, will not have the necessary elements, so to speak, to judge an international crime committed abroad by international actors or non-Spanish actors, so to speak. So it was really just the procedural rule that indicated that when you had these conducts for being considered of general offenses or against human dignity, the different, the language of the 1990s when it came to prior to the Rome Statute, the Spanish courts will have not the duty, but the ability or the faculty, as we say in Spanish, to assert jurisdiction. And that was pretty innovative, and certainly in the Spanish system, because our system, our jurisdictions, our prosecutors were not familiar with this idea. Investigating a crime, and a crime of certain relevance, is difficult enough. And the lack of resources real enough in a country like Spain, certainly, I can speak for a Southern European poor country, to then suddenly facing an investigation that will take 80% in Argentina, where the victims are, or in this case, due to the repression, the disappearances took place, or the bodies were buried. And that was a huge learning curve. And as I said, and then with a very limited criminal code at that time, had not even undergone the most important reform, were conducts such as, or crimes such as crimes against humanity, was not even part of the national system. We will have genocide, which I'm sure Ukraine, and I apologize for not being that informed, although I'm hoping today's the beginning of my learning curve about Ukraine. But I'm sure Ukraine has that. In the 1970s, most countries included in their criminal legislations or in criminal rules, acts, codes, genocide, for instance, because of the convention. But crimes against humanity and other torture, as we describe it today and define it today under the Rome Statute, was simply not included in Spain. So the need of the learning, of the ability to investigate these cases, and eventually with one of the Argentinian cases, which was the first trial, to see that defendant, also require, I think, an important amount of adapting, for lack of a better word, in understanding categories such as use coherence and obligation. And we're part of the Spanish state needed to observe as a country within an international community, and know much more from the perspective of legal tools. Another thing that perhaps I want to throw there for the questions later, that was very precarious in Spain, and I wonder, to be honest, my question to Wolfgang, that was the case in Germany, is international cooperation amongst prosecutorial units. Something that remains a challenge, but to me, crucial and central to the ability to do these cases. In Syria, it's a great example of still how, I think, in how young and kind of baby steps we have taken when it comes to international cooperation in Spain. Just to give an example, we'll have a very developed one with France due to our own terrorist issues. When France and Spain exchange, as you guys share, ETA and terrorism, there was very much obviously the focus of the 1970s, 80s, and 80s and 90s in criminal investigation in Spain, but not beyond that. And it's still very limited, that the ability of Spanish prosecutors to talk to German prosecutors or to British, prosecutors. And perhaps that was also what was brought to the table, and I think to understanding the possibilities and limitation of universal jurisdiction. In Spain, then, just for to get a better picture of the universal jurisdiction provision, embarking that decade in a number of cases. I think every case, and we don't have the time, naturally, I will be delighted to share any information that is required. Every case presented a set of, in my opinion, very interested envelope pushing possibilities. The Pinochet case naturally ended up in the wrong way, in the sense that Augusto Pinochet, former Chilean dictator, at the time a senator, was sent back to Chile and was only tried there, or as I said, indicted later there. But in itself, even though it was not a success from the Spanish perspective, perhaps, I think that for the Chileans and the victims' perspective was a huge success. He was the first official still sitting, he was a senator, and it was to be thrown in jail in a consideration on his immunity as a senator and the ability for him to be extradited and tried in Spain, debated at the Supreme level, at the Supreme Court level in the United Kingdom, in the House of Lords, making a decision that I think has been very relevant in the field. Then, as I said, Spain went through perhaps a little bit more than a dozen cases, and I don't have the time naturally to go in details, but as I said, everyone provided imperfect, which I think that's the one thing about universal jurisdiction as the prosecution of international crimes in national courts. I think imperfection is a word that we should all talk to someplace in our show. There are going to be huge challenges. I think it's obvious, because they are, I said often, there are legal solutions to many times problems that can only be addressed politically by a country. There is not the human rights angle or the more human angle have never been explored. It was just a war, or it was a peace agreement, or it was some repression. And countries have now faced, and this is what I think this movement and the lawyers and the many teams in this field were able to contribute a deep understanding of the rule of law. This addressed of diplomacy, addressed with our laws, and can be addressed with our courts, and can be addressed of obligation and cordial existence and fighting criminality and fighting impunity. And then, as I said, the evolution in Spain was, as in many, I apologize, I'm gonna have someone walking in Spain. Perhaps it's sweet and sour. We had those years where you saw some of these cases advancing. You saw, as I said, some envelope pushing and some new creative ideas that contributed, no question, to the field of international criminal law as we know it, and some of the things that we were understanding from the international community coming together to pass the Rome Statute and naturally the ICC. And then the natural backlash took place, also very associated to universal jurisdiction. I think in every country, several circumstances in different countries, political interest of the time, ended up limiting dramatically in two different moments, in 2009 and 2014. I think the 2009 reform of the universal jurisdiction provision in Spain was was always, all of them were oriented at limiting and at controlling it. But the one in 2009, I would say, was a little bit better spirited, in the sense that we're trying to rationalize through the criteria or the principle of passive personality, something that we've seen as a trend in many countries. I personally don't like it, naturally, I'm a true believer, but you can find some rational, I think, ideas or rational principle, desires in trying to look at these cases when the victims are of your nationality. I think that if we were honest, I don't have particular interest in justifying legislations. I don't think that they were looking at making the cases more feasible or the investigations more plausible. But I think some of them that had the opportunity in 2009 to speak with, they were really looking at making these cases more potentially realistic. And perhaps our colleague prosecutor has an opinion about this, that they felt that they couldn't really do their work, that the prosecutorial office in Spain had no resources and no long arm enough to be able to investigate these cases abroad with all the implications. And that was the idea. Let's limit it a little bit to victims of Spanish nationality. And of course, when we find our perpetrators in our country, in our borders, somehow there's a proximity. And they were, whether you agree, I don't, but whether you agree or not, they were trying to make, as I said, more realistic, pragmatically, the investigation of these cases. And then we saw a different wave of cases, and many of the existing cases were amended and adjusted to meet the victim criteria, the personality or the nationality of the victim criteria. And, Spain, like many other countries, is a country that produce, because we were a very poor country for many years under a dictatorship, so produced more people that left the country, the people that came to the country. We have been receiving immigrants only for about 2 decades for that. And I think that you found also a lot of Spaniards for historic reasons with Latin America, but also for immigration and economic reasons in many jurisdictions. And that facilitated the ability to go forward. And then in 2014, which was a little bit of a surprise, to be honest, and succumbing to Chinese government, which perhaps in that regard is something worth debating here, because we have Russia, which is the second actor, international actor, that, if I may, are bullies. They're not international actors. We have 2 bullies, China and Russia, and they came to Spain and they push bullying in the very style to get rid of some of these cases. And they are now declassified documents. They prove that there were these discussions had at the vice presidency level in Spain, in which it was guaranteed to the Chinese that the law will be changed to limit these cases. And then we had this terrible reform in 2014, that, but it's kind of nutty. I mean, it's so it's so unprofessionally insane that there's not even the legislators today can explain it. But it really came to limit the use of universal jurisdiction. But it's also a law that if you go in detail, which is not for this discussion whatsoever, you can find enough contradictions, and perhaps that's the other message. Nobody is infallible, nobody is what do I say, infallible, we say in Spain, you can find still the gaps and the cracks, even in this 2014 legislation, to be able to bring cases in Spain. Since then, we filed cases. I was lucky enough to lead with colleagues in Madrid. The second only trial that we had on universal jurisdiction in one, when the criticism was, oh my God, so many cases for international crimes, you realize that barely a dozen cases, a little bit more, were ever filed, and only 2 cases have gone to trial. So that is also, I think, a reality that overcomes criticism of overwhelming prosecutorial units or the like. And Spain has resisted, though. There's been enough bills. That's what I think I am particularly excited to listen to the Ukraine moment in the aspirations in Ukraine more than sharing our experience. Spain has resisted the creation of a war crimes specialized unit, something that has been a debate. I believe that was a conquest in Germany in that moment of change when the crime unit also was created. Spain has no specialized prosecutors, which I think is wrong, because you are really in the hands of the private, personal, emotional relationship of the prosecutor to these events, these particular events, or the particular history of a person, and frankly, how comfortable that prosecutor is with international criminal law or international human rights law. Living, in my opinion, showing a little bit our lack of rigor at times and professionalism, and addressing this as a state obligation. I believe that, and I tell me, how am I doing with time? Because I go. Am I almost there?
I am typing to you that it would be wonderful if you could conclude in a minute.
Perfect, a minute. A minute, and then I throw, perfect. And then I throw 2 ideas as a conclusive way. I think that, and that's again where I'm so excited. I wanted to highlight that in the Spanish case that I happen to be present or representing today, which I'm quite honored. And to me, there are 2 things one positive thing and one negative thing that I think we can perhaps take as a lesson and export, if I may, to Ukraine and other countries trying to do it. One is the lack of institutional, which I see some with our deputy today, which I'm delighted, the lack of real willingness to incorporate this field into the prosecutorial, to form people about it, and to create, why no, I'm already almost 50, and they could have all these prosecutors, to create a generation of prosecutors and investigative judges that will take, outside of the personal choice, this international criminal field or this international obligation at heart, realizing how much, in my opinion, national jurisdictions are still, what role they're still going to play, even to make more robust and more relevant the International Criminal Court. And I will leave it at important. And it's not because of my colleagues, it's because it's really where my heart is. It's a civil society. They do not abandon the battle. They do not focus only on the battle of, obviously, it's very important to sign and ratify the ICC. That was a huge battle in Spain to get there. But how important it is that the country matures in understanding its own obligations when it comes to war crimes, crimes against humanity, investigating, educating, providing for whatever support team, etc. How civil society in the country and abroad, all of us, because nobody is doing this alone, will contribute in getting this ongoing. And I'll leave it at that. Thank you very much. I hope I was not all over the place. It was a pleasure.
And Madonna, thank you very much. And actually, you raised so many issues which are very relevant to the, current Ukrainian context, the civil society. And actually, the cooperation with the civil society and state actors here, it has been emphasized how different the Georgian and the Ukrainian responses have been, because both have suffered from Russian aggression. But Ukrainians' impact has been extraordinary, as we could see the joining of the effort between the civil society and the investigators and prosecutors, for instance, not only in building the domestic cases, but in writing joint communications to the ICC, for instance. And similarly, as regards the reform of domestic criminal legislation, what you mentioned, it's not that we did not have the definition of crimes against humanity in Ukraine's criminal code. You will be surprised that now, in the 8th year of the armed conflict, the Ukrainian criminal code still does not have a notion of crimes against humanity and has a very patchy incorporation of war crimes. And with such a loose legal basis, the investigators and prosecutors have to work. And so this reform is really overdue. I will now pass it on to Wolfgang to hear about his experience, and then we will hear the Ukrainian lenses. Wolfgang, the floor is yours.
Yeah, thank you very much, Katarina and Maria, and hello, everybody. Already mentioned, I'm directing the European Center for Constitution and Human Rights. You can have a look on our website. The recent annual report was just published, and there you will also find this map of countries and cases and projects where we're active in. And I'm not showing it because I'm very proud of this world where so many human rights violations occur. I show it to you because, as Almudena said, we're talking about a very imperfect world. And what we're doing is also we move within and try to make the best out of a very imperfect system of international criminal justice, where universal jurisdiction is probably only the last resort. These crimes shouldn't occur. These crimes, if they occur, should be investigated and prosecuted in the country where they've been committed, if not at an international court. And this is not happening, and this is why Almudena, myself, our organization and others are active in bringing these cases now since more or less 25 years, especially to courts in Europe. There are some cases in Chad, the Hisan Habri case, worth to be studied, and also some cases in Argentina, but the rest is more or less playing in Europe. As I can disclose that we know each other now more than 20 years ago, in the aftermath of the Pinochet arrest, which was in a way a wake-up call for civil society actors from all over the world, as well as for lawyers, because we could at once apply our national criminal lawyers' experience to international crimes. That was new for us. It was exciting. It was a time full of expectation, because at the same time, the International Criminal Court was established. Many cases were filed all over Europe from many different regions in the world. The most successful were the Chilean and the Argentinian cases. Why? Because in Chile and in Argentina, we had an extremely strong civil society and human rights movement, where the cases in Europe had a repercussion in Argentina and in Chile. A friend of Almudena and myself, Naomi Arasas, wrote a book called The Pinochet Effect. We could call it the Pinochet and Videla effect, because it's in a way, like others call it, a ping pong effect. It's what happens in Spain, in Germany, in France is not only interesting for Spain, Germany, and France, but also for Argentina and Chile. Or to frame it different, if only something happens in Spain, Germany, and France, this is not enough. It must have a certain repercussion in the countries where the crimes have been committed, and that requires something like a legal system and something like a civil society, and then you get by that. The history of universal jurisdiction in Europe is very contradictory. It's an up and down. After a period of lots of expectations, we have more than 1,000 cases in the main Western European jurisdiction being filed, mainly by civil society organizations. but only a few went to court, and these few were Yugoslavians, old Nazis, and some African perpetrators. Something which led Maximo Langer, an Argentinian US scholar, to the conclusion that universal jurisdiction only works if the price is low. But if the political, military, economic, or legal price is too high, then it's such an obstacle that the states, even if they started investigations like in Spain, like in Belgium, will withdraw. This is what Almudena described for Spain, but we had similar developments in Belgium, in France, in the Netherlands, where now universal jurisdiction is only possible under a very narrow scale. I try to elaborate some thoughts about it. Standards in the international criminal law, not only if the price is high, but also saying this is one of the characteristics of international criminal law, one we have to challenge, and that's double standard. That's especially powerful Western nations only are active only in those cases of human rights crimes where they expect a certain win for themselves, and they don't acknowledge that crimes, their own involvement into crimes, human rights crimes, has to be prosecuted. And I name only 3 groups which are very expressive. So there is a huge impunity gap regarding sexualized violence internationally, everywhere in the world, in every historical period and in every region. There is a huge gap into the prosecution of corporate accountability. So many of the conflicts are caused by economic factors. Economic actors are active, but they are not investigated and prosecuted. And last but not least, something which is also forgotten in especially Western European narrative, that's the colonial crimes. They forgot that they colonized half of the world and committed crimes which now would be prosecuted by the International Criminal Court. And until now, they ignore it, and they see no causality between the fact that many countries do not acknowledge international criminal justice, and the fact that these countries suffered serious crimes by the colonial nations. So that was the story of universal jurisdiction in Europe, which is now, let's say, after the very wild first 15 years, more or less a stable institution in many countries. Some countries can investigate and prosecute more, some less. My own country, Germany, is a little bit more open, as well as some of the Scandinavian countries. And you mentioned already in your introduction the cases of the Syrian torture crimes, which are investigated and prosecuted in half Europe. So we have investigations in Switzerland, in Austria, in Spain, in France, in Sweden, in Norway, in the Netherlands. And the biggest investigation complex we find now in Germany. So after Belgium and Spain as the first countries where universal jurisdiction was exercised, we have now Germany. Why Germany and why Syria? Because Germany has a very, let's say, open for international crimes, open criminal code, the so-called Code Against International Crimes. Second, and that's definitely something you have to bear in mind, they have now at least some more resources to investigate these crimes with the War Crimes Unit. And last, but definitely not least, because we have nearly 1 million refugees from Syria in Germany. So there is a strong link between Germany and Syria, the Syrian crimes, because many of the people who fled to Germany are survivors of the crimes committed in Syria. So it's not that far away as other countries' crimes, historical crimes, current crimes might be. So in the beginning of the investigations, and you see it also in Europe, most of the procedures were directed, I would say, against terrorism suspects. So suspects from the various groups, maybe from ISIS, maybe from armed oppositional groups in Syria, and against those perpetrators and suspects who at some point find themselves at European territory. And that's what we call kind of safe haven, universal jurisdiction. Means that the claim of the European countries is Europe shouldn't be a safe haven for war criminals against humanity. And a little bit opposed, somehow it's discussed, is the so-called global enforcer function of universal jurisdiction. And that means that universal jurisdiction cases contribute to the establishment of a broader concept of justice. And the interesting thing is, as it was discussed in the beginning of this discussion, this was discussed either safe haven or global enforcer application of universal jurisdiction. Whereas in Germany, we found now a complementary model. So Germany arrested some people at the German within the German territory, but is also looking into the accountability of the higher ups of the Syrian regime through international arrest warrants, and which is opposite to what the German prosecutor said 10 or 15 years ago, when we, for example, filed cases against Donald Rumsfeld and other US military and politicians for torture in Abu Ghraib and torture in Guantanamo. They would say, no, these people are not coming to Europe, and so why should we even start to investigate? Whereas now they developed an understanding of a very complex division of labor between local national prosecutors and international bodies. And this is particularly impressive in the context of Syria, because, as you all know, this is a case that should be investigated, prosecuted at the International Criminal Court, which is for several reasons not working. But we have UN bodies like UN investigative mechanisms. We have UN resolutions calling for the prosecution and investigations. And we have a whole network of cases within where Germany might be at this point the first, but it's definitely linked to others. And that is, I would say, is kind of a next stage of universal jurisdiction. It's a very interesting stage. Molina, you asked about international cooperation. In these cases, we see a lot of cooperation in the so-called Eurojust and other prosecutorial networks. One can say this is due to the fact that at least Western European nations are very eager to go after the Assad regime. Of course, it's in accordance with the political and economic and military interests of the Western nations. Still, it's an effort which might lead us in the future to a universal application of this standard, of this practice, which would be a major step forward. And I think the only way to achieve that is, in fact, and we all emphasized it so far, is a strong initiative by civil society actors, because especially when it comes to obstacles, the states are not the first who take up uncomfortable cases. So it's up to us in the respective country where universal jurisdiction is exercised to mobilize civil society and also the opinion of the society, which was, and probably for the first time in Germany, achieved in the Syria cases. So it was not the xenophobic discourse oh, these Syrian refugees, instead of being grateful to Germany that we host them, they even go to court now and, you know, bother our courts with their crimes. There was nothing like that. The other way around, it was in fact a very emotional narrating of their stories. These people fled here because they had suffered incredible crimes back in their country. They might go back if their country is in a certain democratic and just order, but for now it's impossible. So, I would say it's an exceptional example, which is difficult to compare, as well as the Argentinian experience is difficult to compare, but that doesn't hinder us, neither ECCHR nor other organization, to file also and to pursue other cases. Now, I wonder that you didn't mention the case we made public last week, because it was a case against Russian perpetrators and suspects. It was a case of crimes against humanity. We launched a criminal complaint into the repression against the LGBT community in Chechnya, especially torture, forced disappearance, and persecution, and instigation for assassination, which will be then a completely different procedure, because obviously Germany invested a lot into the Syrian crimes, but they won't be able, and they won't be resources also into other crimes. So the Syrian is extraordinary. In other cases, there might be less efforts and less resources put in, and that's a question basically of civil society pressure, and also of the possibility of mobilizing public opinion. I'm not feeling very comfortable to at all comment into the perspectives of any kind of Ukrainian issue in universal jurisdiction cases. People, experienced lawyers and organizations like Almudena's and mine, normally take very much time into discussing with the people who want to bring these cases, and this can last months or even years, how to bring cases, how to develop cases, to discuss the goals. You know, if you want to scandalize something, if you want to make a certain crime more visible, if you want to deliver an accurate documentation of the crimes to a national court and make it then also available for others, or whatever goal you may have, that may be a whole variety of goals, but it's not a fast race. It's something you have to be aware that this might last very long, but all the cases which led to something like a judicial success, I'm very hesitant to talk about successes, because crimes against thousands and thousands of people have been committed, and then one judgment, one convictions against one perpetrator is not particularly a success. It's a small step forward towards justice. Justice will never be achieved, but this is the kind of conversation we are leading with people from countries who are interested in bringing universal jurisdiction cases. So it's nothing we can deliver at a Zoom conference or in a, let's say, quick recommendations, but obviously it's worth to discuss more thoroughly in whatever format. Thank you very much.
Thank you so much, Wolfgang, for this comprehensive presentation. And I actually have lots of questions, but before that, I would like to proceed with Ukrainian perspective, as it was announced by Katerina, and provide the floor to the representative of Ukrainian General Prosecutor's Office. Гуду Зайдиновичу, ми би хотіли зараз вам передати слово і попросити вас прокоментувати.
So, Mr. Genders, we would like to give the floor to you. We would like to ask you to comment on two perspectives. Well, let's first focus on the first. And this is the perspectives of the application of universal jurisdiction in Ukraine to try to prosecute people who committed crimes against humanity in the east of Ukraine and in the occupied Crimea. We know for sure that Ukrainian prosecution has looked into universal jurisdictions as a possible tool, one in the set of tools which Ukraine is trying to use. But we have just heard that out of thousands of cases which are prepared, only two ended in verdicts. So, is it worth it? What do you think? Should we try to pursue this instrument? Is Ukraine trying to pursue it? Are the prosecutors qualified, especially those who work in the Department of War, so to say, or the Department of Peace, as another nickname says? Or you think that this tool is not worth of the effort spent? What is the priority tool for Ukrainian law enforcement bodies? Because now we have a unique situation. It's not only about the civil society, which is trying to increase the attention to this prosecution, but also we're talking about the question of a different state. So now, Mr. Manetov, the floor is yours. Your microphone is muted. If you could please unmute your microphone. Thank you. Thank you so much for raising this important issue. And I would like to say thanks to the organizers for raising this important topic. Universal jurisdiction for Ukraine, in my opinion, is a promising opportunity to find alternative means of achieving justice and accountability for grave international crimes. We have studied the experience of other countries. You're correct. We have looked into other possibilities, and we looked into the case law, and we saw that the case law in different countries is not very consequential. It's not very aligned, and also the perception is quite different. The understanding of extraterritorial investigation of these crimes, well, it varies. And maybe this is not a good example, but the very recent case when a Ukrainian airplane was shot in Tehran, and the Iranian colleagues were asking, why is Ukraine trying to prosecute the citizens of Iran for the crash of the plane? So, yeah, indeed, any extraterritorial investigation would raise lots of concerns. And for Ukraine, as I already said, it is still one of the possible tools which it could use alongside the ICC, because the colleagues from Spain, from Germany, they discussed, for example, about the application of universal jurisdiction in their countries. And that is good news. We spoke already to our German colleagues regarding the mercenaries. We have already identified 5 citizens of Germany who were mercenaries on the side of the Russian Federation, and they were fighting against Ukraine. So these letters and memorandums we are sending to our international partners, requests for information, we're trying to explain all the time that these people may be complicit not only in the violation of convention, also could be complicit in grave international. We have been sending similar requests to Spain. As far as I remember, the 27 citizens of Spain who were mercenaries on the side of the Russian Federation. And overall, out of 32 countries whose citizens were mercenaries in Crimea and in the east of Ukraine, we have identified about 260 persons. And yeah, of course, perhaps many of these people took active part in combat activities, and they could have been complicit in war crimes and crimes against humanity. That is why we are now keeping the active dialogue with our colleagues. We are asking them to facilitate these investigations. If we talk about Ukraine's participation in this mechanism and the prism of universal jurisdiction, well, my response would be probably using the quotation of a famous lawyer, who said that firstly, they should be the interest of the state, and secondly, they should be the protection of universal values. So, on the first thing, of course, Ukraine has a lot of interest because there are many people who were somehow involved, who were funding the activities, and they have assets in the European countries. Some of them remain in the countries of Europe, and they keep funding the
Активно вот эти действия, которые происходят.
And they keep funding the activities in the east of Ukraine.
Касается охраны
And
универсальных.
speaking about the protection of some universal values, here we have to think very thoroughly. And here we have to do our best to explain to the society what that is, and for us to have not just the desire to actually send requests to the European countries for them to be prosecuting people who have anything to do with severe crimes, but for Ukraine itself to be ready to do the same with the citizens who come to the territory of Ukraine. And for that purpose, at the beginning of 2000, the department was created, which was mentioned several times here. So, there was this idea to call the department on actually investigating international crimes. So that was the idea. And, we could have been misunderstood, which is why we've changed the name back then. And the department in general, within a year and a half, was actually learning the basics of the international criminal law. Quite professional people work there, and they are good experts in the area of international public law. They are actively using it in their work. Also, we have 2 units in Donbass, in Donetsk and in Luhansk, which are directly dealing with the armed conflict, meaning the systemic violations of the international humanitarian law norms. And the department itself is dealing with the armed conflict, armed aggression. And if you ask me whether Ukraine is ready and whether our department is ready to investigate such crimes through the lens of universal jurisdiction, I would answer that, well, in general, yes. But for that purpose, we need to have certain legislative normative base, which would allow the prosecutors to actually investigate the crimes and be involved in appropriate proceedings. And we strongly hope that in the second reading, our MPs will vote for the draft law, and we will adapt the international humanitarian law and will harmonize our legislation appropriately. And by the way, the Prosecutor's Office of the Crimea and the Department of the General Prosecutor's Office took active part in implementation of the international humanitarian law and the principles of universal jurisdiction are mentioned there. And I believe after Ukrainian law is appropriately harmonized, we will be prepared to use it for our benefits. Well, what are the questions you had to me? Yes, actually, you've answered them all. Before Katerina will ask her questions to us, because I'd like to clarify one thing. Well, maybe even two small clarifications. I know that for the prosecutor, it's not a good thing to comment on the presence of a political will, but whether you see the readiness in Ukrainian parliament to introduce amendments to the criminal code, which will allow Ukraine using the tools of universal jurisdiction, and whether there is a capacity. That's the second question. Because in Ukraine, we have so many cases pertaining to some domestic crimes and international crimes taking place in Donbass and in Crimea. Maybe we need to boost our capacities, or do you see we have a resource to investigate these crimes? Well, thank you for your question. We have to speak about solidarity here in the first place. If we would like our cases to be investigated abroad, then we should be involved into something similar, right? So I have this general understanding, because if we do the same, we will create the international criminal justice environment, so to say, right? And for Ukraine, it's very important that plenty of Western countries show solidarity in these actions. I believe that Ukraine is obliged to investigate such criminal cases, such crimes committed within its own territory, once again through the lens of universal jurisdiction. Speaking about the political, it's out there, as I've mentioned, and using this opportunity, I would like to express my gratitude to the committee of Verkhovna Rada, which is supporting us in this very situation. And I strongly hope that the parliament is going to vote for this initiative, and it will make our lives easier. Thank you. Katya.
Question to Almudena. Almudena, in a couple of your interviews concerning the trials, the Jesuit priest trial, you mentioned something which quite surprised me, because we're used to this formula that justice delayed is justice denied. But in the case of that trial, you said that actually it took, I think, 12 years of your career. But in that case, you think that it was useful for the whole criminal proceeding. Could you explain a little bit more? Because I think people, especially in Ukraine, they're so disillusioned and they obviously want the convictions and the progress straight away. When do you think time actually plays in favor in such proceedings? Thank you.
Thank you, Katerina. And I actually have a few questions from our deputy prosecutor. No, first I think that I would say this with the understanding that justice to be justice has to be prompt and has to be something that we all believe that. And there is some detriment, naturally, the general is associated with the lapse of time. And perhaps being the eternal optimistic of having been done for so many years under such adverse circumstances that I realized, and this was true in the Jesuits, Katerina, so thank you for mentioning that precisely because these investigations touch so much political interest of a particular moment in history. Sometimes the context were complicated. In this instance, we're talking about a little country in Central America, El Salvador, which was a huge geopolitical priority for the United States. The country immediately on the north, with all the power that we know in the 1970s and 80s, is suddenly the changes, I think some maturity, some political different waves in understanding of the world and its presence, in this case of the United States in relation to the rest of the world, had made this lapse of time to be a positive thing. And in terms of evidence specifically, just to be very concrete, in the process of evidence, and I'm sure that my colleagues in the panel have an opinion. I mean, one of the challenges and why this is beyond having the legal basis, as the deputy was suggesting, and others, I think that we do have the tools. It's just very overwhelming to think about something that happened 30 years ago and start even thinking about what evidence am I going to put together. Some witnesses have passed naturally because of the pass of time, and evidence can be destroyed or made more vulnerable. So this is part of the, to me, a very human response to this, like, oh my God, how am I going to do this? And in the case of the Jesuits, because of all these political circumstances and having this triangle of Salvador, Spain, and the United States, when it came to documentary evidence and frankly even witness testimony, which I will say are the two heavy lifters, pieces of evidence in this kind of investigations and prosecutions, we were able to obtain more information precisely because I think it's a number of reasons, but I could identify in the specific case of El Salvador. I think some of the fears had vanished. I think that I think there was some codes of loyalty within the armed forces that for the first time in the history of the modern history of El Salvador were betrayed by some soldiers, understanding the world differently. So I think that combination of factors, but also change of mentality and circumstances, allow us, I think, to present a stronger case from the evidence perspective, no question.
Thank you. I have a few questions to Wolfgang, if I may. First of all, to be honest, I'm impressed with the statistics that you've mentioned, that out of 1,000 cases, you had only a few convictions, only few cases are brought to the end. So I'm wondering, why you still dealing with this instrument, which seems to be quite unstable, I would say, and not promising any substantial outcome. And I would really like to ask you also to share with us your sort of experience of participation in this Syrian case. What was it exactly? I think it would be very interesting for our colleague from the NGO sector. What was your role precisely, and how did it all work out? And the third question is related to this political will issue that was mentioned by you and also by Almudena. So, for instance, with Germany, we have this whole issue with Nord Stream 2, right? So it seems to be there, although lots of obstacles for this project, but it's still kind of on the table. And then you have all this story with the elections that are coming, and maybe the change of the sort of political will to some extent. So do you think that your case on Russia that you mentioned, which is related to the LGBTI aggression against LGBTI people in Chechnya, can be successful given all this political stuff?
Yeah, thank you very much for your questions. It depends on how do you find success. That's the very easy answer. That's the answer to question 1 and also to question 3. It's one answer. I filed a case against the Uzbek Minister of Interior Almatov after the massacre of Andijan a couple of years ago. And in this case, it's the families of the victims as well as torture survivors were already satisfied because we named for the first time the minister and other functionaries war criminals and criminals against humanity. So it can be already an achievement if you, in a sorrowful investigation and research, you sample the facts, which is important, and that is more than just collecting newspaper articles and Amnesty and Human Rights Watch reports. And second, if you take the time and carry out a long legal assessment, because it's a difference to call it a scandal or morally or ethically scandalous, or to call it an international crime. If you call it an international crime, you have to undertake some effort to prove it, at least in a preliminary analysis. And that is an important first step. And for some people, that is already an achievement. Others go straight forward. But my understanding of this work is not, I don't think that we ever can go from A to B. It's like we start at A, and then the situation is always open in every regard. And that's actually a good news, because 25 years ago, it was not open. The tool was not available. It was not available because we had not the imagination. And that brings me to a famous human rights scholar, Catherine Sicking from the US, who, now I turn to your statistical question, she says instead, and she refers to a political philosopher, she says, first of all, this discourse around the failure of human rights, the failure of a human rights paradigm, and I could add the failure of international criminal justice, the failure of universal jurisdiction, is first of all wrong, because if you look into the statistic, you would see, and we did it at my organization in Berlin several times, if you go around the world, around the globe, and see what crimes of, let's say only crimes against humanity of large scale have been committed during the last 50 years, and if you look then how many different procedures have been carried out in very different fora, you will see a lot. It's a lot. In fact, it's a lot. And it was unimaginable 25 years ago, and you have seen several unimaginable stories happening. And that is what Catherine Sicking points to. She said, we don't have to look into what's probable. We have to look into what's possible, And what is possible is, on one hand, a question of imagination, and obviously, on the other hand, a question of many different factors. And I had the pleasure to work in the German-Argentinian cases. And look, we started, I think I started with a 30 pages complaint in 1990. And we ended up in arrest warrants against two of the junta generals 2 years later, or 3 years later. And yeah, it could have been one goal, but we were never ever, thinking of this should happen, this might happen. We were never ever thinking of defining our work as successful or not successful, because this is going to happen or not. And this goes even more for people like, filing cases against Donald Rumsfeld. People would say, are you crazy? Why do you do that? This is never going to happen. Yes, it hasn't happened until now. Even my lifetime is a little bit longer, hopefully. And so me and others are still working on that cases. But second, between the ultimate, however you want to call it, judicial success, a conviction, there are many intermediate steps. And in the Rumsfeld case, for example, it was exciting. It was exciting because when we started this work, everybody was saying, what are you doing? What are you doing? And, when we filed the case for the first time, media and civil society all over the world were saying, okay, wow, Rumsfeld has committed war crimes, and he was not only considered as a failed politician, but after our complaint, also as a war criminal. A war criminal from a very powerful nation. We couldn't prosecute at this time. But later on, it turns out that Rumsfeld, even former President Bush and others, didn't travel anymore to Europe. You can say this is not the ultimate success, and you're right. But this is a step, an important step forward. And so not imagined by many people, not considered as probable, but it was possible. And more would have been possible, more people would have committed to this cause. And so it won't change a lot in Germany, I will tell you. And our expectation for the LGBT case, we will see. I mean, it's already important to make the case, you know, to make it visible what happened to the LGBT community in Chechnya. Obviously, we will do as much as possible to bring the case as far as possible, but we wouldn't consider it as a non-success or as a failure if the prosecutor wouldn't come up with a meaningful investigation, because we always bear in mind, and that is obviously something you know, my prosecutor colleague Mamedov knows perfectly. It's difficult to investigate crimes abroad. It's very difficult to investigate extraterritorial crimes. And by the way, and this is probably the only thing I comment on the Ukrainian-Russian conflict. If you look into the successful cases, you know, it were mainly torture cases, combination torture, assassination, crimes against humanity. And there were very, very few successful cases of international humanitarian law, because IHL is very, very restrictive. And we made our experience. We brought some cases, you know, lately. You might have heard the Afghanistan bombing case, the Kunduz case. We tried to bring it at the German courts. We were not successful at all. Then we brought it to the European Court of Human Rights. You might know the decision in February. It's even worse conditions. It's even worse legal prerequisites, because the legal framework is so narrow, and that might be a relevant factor for your cases.
Thank you so much. I have one small clarification to both Wolfgang and maybe Almudena would also like to comment on that, because you've been mentioning those intermediate steps. And I can say on our behalf as Ukrainian civil society, of course, we strive for the justice, for the accountability, but we also use such instruments as sanctions, for instance. So we filed the submissions to the US government. We're going to file the submission to the EU. Also, as now we have this Magnitsky-like legislation, do you consider this as this intermediary tool that can be used in order to, you know, to at least somehow not punish, but to make these people know that they are not going to go unpunished in the end?
I'm not really convinced of sanctions for two reasons. One is, I think a very important step forward are the investigation. So investigating the facts of the factual side of any accusation, I think is incredibly important, because, you know, the process of establishing memory and justice is not only something that should be carried out by the legal system, especially not only by the executive, but it's I would say at the end of the day, you need a commitment by the whole society, and therefore you need to deliver the facts in order that society can deal with it. And that is not at all happening in the sanction system. And the second thing is, as you saw from different complaints against especially the terrorism list, which are applied all over the world, it's often against any rule of law to just put some names on a sanction list without giving the people to defend themselves, without judicial control, which led to a number of decisions of the European Court in Luxembourg against the European terrorism list sanction system. So I'll be skeptical for a number of reasons, but that doesn't mean, you know, it's let's be also pragmatic. If you have no other tool available, I would say, why not? It's always a discussion you have to deal with. Are you really strengthening democratic rule of law with certain tools or not? Does it have their advantages, or does it balance out the weigh out the disadvantages? That's at the end of the day your decision.
Thank you so much.
Just Maria, just to add a little bit, sorry. I'm very ambivalent as well. You know, we haven't talked about it, Wolfgang and I, about this, but in the United States, you know what, I've been living for a number of years. The sanctions are a way deliberately to be, first of all, just subjective about who you include in those sanctions, and generally advances political strategies or agendas. They have very little to do with public interest or with with educating societies. So I'm not saying don't use it. I think it's a mechanism, and we have so little that I would say yes, everything has to be used. But I agree. It's one-sided. It's short-sighted. And it's not that, I mean, it also depends on what region. I think it has been effective in Latin America, precisely because of the relationships that the United States has with some of the dictators and thugs in the region. But when it comes to the Middle East and others, has created realities. I'm very ambivalent. So not to get rid of them, but to be much more thoughtful on how they are used, in my opinion.
Thank you so much. And Modena, I know that you wanted also to ask a question
Yes, if I may take to the deputy. He mentioned, he addressed a couple of times in his intervention the lack of a legal base or a legislative base in Ukraine to be able for his unit and what he's aspiring and pushing for to act. And I just wanted to understand, and this shows my ignorance of the legal system, why is that decisive for the prosecutorial unit? Because I just wanted to throw out there that none of the countries that have developed, and I think I said this when I spoke, that none of the countries that kind of adventured themselves had the legislative basis beyond perhaps, a very obscure provision or mention in the national systems. And mostly what it was, which I find fascinating, was a way of understanding the scope of having signed international treaties and conventions and how to apply those treaties and conventions, whether through constitutional avenues or direct international use coherence and the like obligations in the national systems. And we are seeing it right now, Deputy, in South Africa. Right now, the prosecutor, the attorney general in South Africa has decided that the apartheid cases were not investigated. The victims were left pending, that the Truth and Reconciliation Commission was successful, no question, at a very high cost, which is kind of denying the victims any access to justice. And they are trying to undo these by opening some investigation. It's been very much an uphill battle for the Attorney General and her team, trying to make the parallel with you and your team. And we've been trying to support. They don't have the legislation, and it doesn't look like they're going to have it anytime soon. So we've been trying to help them to brief how to back their actions with their own international obligations. Sorry, it's a super long question, but I was wondering if that's something that your team is contemplating, or you think that there is lack of comfort or expertise in that regard. I was just very curious, to be honest, because it's a problem that we all have gone through.
Hindu Zaidanovich, відповісте, так?
So,
Мікрофон.
Mr. Mamedov, please unmute. And can you hear me now? Yes. Thank you. Thank you so much for your question. Currently, we have no legal grounds to apply this tool at the moment. As Maria has duly noted, in the national criminal law, we have crimes such as genocide or war crimes. But, however, here we have to apply the territoriality principle only if it is related to our land. We can apply this norm, and unfortunately we cannot apply universal jurisdiction in these cases. And in general, if we talk about the opportunity, I would say no, we don't have the opportunity and the capacity, but because we are understaffed, overloaded with all the work on Crimea and the East, and there's a whole layer of work which is left behind, because since the beginning of the combat activities, since 2013, since the aggression, and up until probably the end of 2019, not much has been done, with the exception of the prosecution office of the Autonomous Republic of Crimea. They started very active work in 2016, and many participants here, they were very helpful in the foundation of that body and in training of the prosecutors with the foundations of the international law. And still, we have Article 438, which is the breach of customs of war. And if you remember the case law of Yugoslavia, they had this same case. It is an open definition article, and we can reference international treaties when prosecuting under this article. And of course, the prosecutors sometimes were not aware of all the treaties. We have identified at least 30 conventions that were relevant for the prosecution under this clause. Actually, that is why we had to update our knowledge back then. So in general, we're willing, and in the future, we hope, we expect that the department would be transformed, and it would target all similar grave crimes under international law, and the prosecutors are ready and willing. So hopefully, the nearest future, we will have more experience, and then we would be able to apply the tool of universal jurisdiction.
Dear participants, I'm very sorry that we cannot ask all the questions that we have received. Unfortunately, we're running out of time. I'm thanking everyone for participating in your respective time zones. And I made a special note to draw the attention of everybody who hasn't looked at Gymnica 37 Chambers podcast, which is called the Gymnica Accountability Podcast. It's totally amazing, and it really merits your attention, so please do. And the book with which Wolfgang showed, The Double Standards of International Criminal Law and the West, as well as another one on colonial wrongs and access to international law, is also available online. Freely it can be read, so I'm hoping that you will avail of that opportunity as well. And also my special gratitude to our speakers today, because I think it was been extraordinary today that we spoke a lot about idealism, but very purposeful and result-oriented idealism. And it was very inspiring to hear from the three very experienced jurists as to how to bring that all into practice. So thank you very much for that. And we will post the recording of this webinar as well as the transcript of the principal quotes from it very soon. Thank you very much for joining us today.
Thank you so much. And we will also share all the sources that were mentioned by Katarina with those people who registered, so you will be able to download or to access them online. Thank you.
Thank you very much.